and a professor of Latin American studies. I teach courses on Latin American history. I occasionally teach courses on other topics. Today's lecture, Unpacking Immigration Law, is an overview of some of the issues that we should understand today from a historical perspective in terms of how, first of all, where the United States is now with respect to immigration law, and secondly, how we got here. So I'm going to go ahead and begin. I framed this presentation through the lens of this question: what is the relationship between immigration and citizenship in the United States? We'll begin with historical context, then I'll spend a lot of time on the constitutional framework for immigration law, specifically the 14th Amendment. We'll also discuss immigration and naturalization more generally, primarily from a historical perspective, highlighting some of the issues that continue to remain relevant today in discussions about immigration, naturalization, and now perhaps the latest issue that many people are asking about, denaturalization. And so that'll take us into a couple current issues, particularly temporary protected status, or TPS, and its partial revocation last week, as well as this ongoing discussion about denaturalization. And there are historical precedents for the latter. And part of my goal today in discussing the history of immigration and naturalization in the United States is to understand how that historical context may shed light on the present. I'll begin with the caveat that I am a historian and I am not a constitutional law expert per se. I will also say that there is more to this topic than we can possibly cover today, so I'm happy to accept questions at the end of the presentation. I want to begin with a series of events that I think are important to this topic. In a lot of ways, when we talk about immigration history in the United States, we're fundamentally dealing with the question of who is the United States as a people? What does it mean to be American? And the term American is a term that people in the United States often use to describe their nationality, but throughout the hemisphere, it's a term that is widely used continentally. In other words, the United States does not, in fact, have a monopoly on this term. So I will make this distinction by referencing US Americans and the United States accordingly. In recent years, there have been two books that have helped us think about this question of US identity in very profound ways. One is the book here on the right, The 1619 Project, which raises the problem of how we conceptualize US history from its very founding. And the second book does a similar kind of gesture, The Rediscovery of America, by focusing on Native Americans in the United States. When we think about the narrative of US history that many of you probably learned in your AP history class, you probably think about the founding of Jamestown, Virginia in 1607, 1608. However, the first European presence in what is now the United States was not in the Northeast, but rather in St. Augustine, Florida. In 1565, the Spanish Empire established the first permanent European presence in what is now the United States. This is important because when we think about the narrative of US history, by beginning the story in Jamestown, we forget that this story is not, strictly speaking, about the British. It is a much larger story. And this, of course, is tied into a kind of debate about the United States national identity. So I offer that as a caveat. And as a related caveat to this, I'll state the obvious. Unless someone in the United States today is Native American, they do not have any kind of ancestry to the United States that is not tied to questions of migration, either forced migration in the case of racial enslavement as this book, The 1619 Project, demonstrates, or migration throughout the course of usually the 20th century with some earlier 19th century precursors. All of this bringing us back to the question of who or what is American, who or what qualifies as American. If we think of the Constitution as the founding of the United States, the so-called law of the land, the Constitution was ratified in 1788. We have to recognize the fact that this is an imperfect document and there were some fundamental problems with it. The most obvious problem, of course, was the fact that African Americans were excluded from citizenship, as were women, and I'll talk more about women a little bit later. And this distinction between free and unfree labor that was in many ways established in the Constitution and previously in the Declaration of Independence led to the U.S. Civil War, as most of us know, and ultimately to an era known as Reconstruction. After the Civil War, the U.S. government had to rebuild its structure, and as part of that process, it passed a series of what were known as Reconstruction amendments. The most important one for our purposes is the 14th Amendment because it largely deals with questions of citizenship and naturalization. However, as we'll see, even the provisions that were established in the 14th Amendment, including the right to universal birthright citizenship, were not always borne out in practice. We can find many examples of this. There are I have a list here, about 20 different Supreme Court cases and pieces of legislation that the United States enacted from the late 19th century and has continued to enact up through the present, exemptions, if you will, to the provisions established in the Reconstruction Amendments. The first of these, as some of you may know, was the Chinese Exclusion Act of 1802, not repealed until 1943. This was the first law in the United States that explicitly prohibited a certain national group from entering the United States, in this case, targeting Chinese people and people of Chinese descent. Later on, we have what is known as the Expatriation Act of 1907. I mentioned that one of the problems that we find with the 14th Amendment is the question of gender and whether women are considered citizens. Well, the Expatriation Act suggests that that was not the case in 1907. Women were forced to adopt the citizenship of their husbands. There's an assumption here that women were to be married, and specifically targeted women who were married to men of other nationalities, including people of Chinese and other Asian nationalities. This was later repealed in 1943 and 1922, and there were a couple cases in between, but fundamentally the question was whether women were considered citizens, if in fact that was the provision of the 14th Amendment to grant citizenship to everyone born in the United States. The next major example that we have is the Executive Order 9066, enacted by none other than FDR during World War II. And this is the infamous executive order that establishes the provision for Japanese internment camps in which Japanese Americans, including those who were U.S. citizens, living within 100 miles of the western coastline, were forcibly interned during World War II. This was after the bombing of Pearl Harbor. Fast forwarding a little bit, we have what is known as Operation Wetback in 1953 and 1954, which was another attempt to specifically target a population of a certain national origin, in this case, people of Mexican descent. During this period, there were a number of Mexican farm workers in the United States, most of whom were here legally. And there were also previous generations of Mexican Americans who worked in that industry, specifically in California, in Texas and Arizona. And they were targeted through a series of immigration raids. It was not the first raid of its kind. There had been a previous raid of that nature during the Great Depression, but this instance is one that I think particularly comes to mind when we consider some of the issues currently taking place, once again, in California specifically. So I want us to think about this timeline, and I'm going to zoom out a little bit now and turn to the 14th Amendment. This is a typo, of course. It should say 1868. Pardon my typo. The Reconstruction era, which was the period following World War II, is sometimes described as the second founding, specifically the Reconstruction Amendments. If the Civil War was caused by an imbalance of so-called free and slave states, then this was tied to the question of citizenship, who counted as an American. In 1857, the Supreme Court ruled in an infamous case known as Dred Scott that enslaved people could not sue for their citizenship because they were not U.S. citizens. In fact, they could not sue in a federal court at all, completely depriving them of any type of federal rights effectively. This was one of the causes of the U.S. Civil War, and the 14th Amendment sought to resolve this question. I'm going to read a portion of the 14th Amendment for us. Under Section 1, it states, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state in which they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. This is possibly the most important paragraph in the Constitution. It is the first section of the 14th Amendment. Constitutional scholars recognize that there are four clauses embedded within this section. The first of which is known as the Citizenship Clause. It implicitly overturned the heinous Dred Scott decision of 1857 by stating that all those born within the United States were U.S. citizens. This included African Americans, and the 13th Amendment have abolished racial enslavement in the United States. So this further reinforced that. And in doing so, it established what is known as the principle of jus soli, or birthright citizenship, quite literally meaning in Latin, someone born on the soil is a citizen by virtue of the fact that they are born on the soil. Now, if we read a little bit further into the 14th Amendment, we will see that it introduces the notion of male citizenship, or more specifically of male suffrage. This is going to raise the question of whether women are citizens, and if so, whether they are equal citizens to men. We're going to come back to this in a minute. The other clause that's introduced in the 14th Amendment is known as the Privileges or Immunities Clause. I didn't read the full text of the 14th Amendment, but essentially this guarantees U.S. citizens, now defined as those born in the United States, with the right to travel. In this period, in the late 19th century, this was particularly important for African Americans who may want to leave their home state and, say, migrate northward. This is part of a large movement that comes to be known as the Great Migration. And this continues up through the mid-20th century. So this means that anyone has the right to leave to another state. Previously, African Americans, and prior to the Civil War, particularly those who were enslaved, did not enjoy this right. So this is an important provision that's enshrined within constitutional law at this point. Similarly, we have the right to habeas corpus. This is something that, if you've been watching the news the past 6 months or so, has been a very important topic. There was a prominent politician who was asked what this right meant, and they were unable to answer this question. So we need to understand what this means. This means, in Latin, basically, the proof of the body. The idea being that you cannot, a court or any type of administrative official cannot accuse someone of something without evidence to the crime. This is closely tied to the notion of due process. In the context of the 14th Amendment and its subsequent application, it's important too because it establishes the principle of limited rights for non-citizens. Now, until recently, at least theoretically, non-citizens enjoyed, including tourists, enjoyed most of the same rights as US citizens, including the right to free speech, including the right to post whatever they may want to post on their own personal social media platforms, including critical information of the US government. This is something that has been called into question quite recently, and you can find many examples of this online in news stories. It's something to keep an eye on. Closely related to the Privileges or Immunities Clause, we have the Due Process Clause, which is essentially a reinstatement of these principles, reinforcing the rights of the guaranteed under the Fifth Amendment, the rights of the accused, the rights of habeas corpus. In other words, meaning that people cannot be tried for a crime without evidence and without usually a trial by jury. Life, liberty, or property, in other words, as the 14th Amendment states, are guaranteed. And until recently, it was understood that most of those guarantees applied to everyone in the United States, regardless of citizenship status, or they also included travelers to the United States. Now, this is coming under question, even though the Constitution is quite explicit about this. Finally, we have the Equal Protection Clause, which means that states cannot discriminate on the basis of race. Later, the court ruled that gender, to a lesser extent, was also a protected category and is also a protected category. There are other questions about the Equal Protection Clause tied to gender expression that we probably won't have time to get to, but I want to highlight the significance of the 14th Amendment in establishing these rights. Now, having said all that, we're going to see a series of exceptions. I'll read this part again from the 14th Amendment. All persons, excuse the typo, born or naturalized in the United States and subject to the jurisdiction thereof. What does this mean? Well, it means that African Americans were definitively granted citizenship. It also means that Native Americans were granted citizenship, though that was less explicit, which is why Congress passed the Indian Citizenship Act of 1924, reinforcing this principle enshrined in the 14th Amendment. Now, the question of and subject to the jurisdiction thereof is going to become a little bit thornier because when we look at the map of the United States around 1898, which I'll talk more about in the next slide, we can see that the United States was beginning to expand beyond its continental dimensions. And to this date, there are a number of what are known as unincorporated territories in the United States. Probably the best example of this is Puerto Rico and the US Virgin Islands here in the Caribbean. But there are actually several places that still conform to this jurisdiction. So the question of, and subject to the jurisdiction thereof, will apply in those cases. Will the rights of the Constitution, including the rights to citizenship in the 14th Amendment, apply to those individuals? What, in other words, does this clause mean, and subject to the jurisdiction thereof? So we've established that under the 14th Amendment, citizenship exists for all people born in the United States, in that this amendment was established initially to protect the rights of African Americans, later extended to Native Americans. But what about women? The 14th Amendment limited suffrage to male citizens. In fact, it's the first time that the term male or male citizens is introduced in the Constitution, if I'm not mistaken. But, or rather, as a result of this, the Congress took this idea and ran with it. And in 1907, it passed what was known as the Expatriation Act. As I mentioned, this law meant that women had to assume the citizenship status of their husbands. So if they married a non-citizen or if they married the citizen of another country, they would lose their nationality. The United States did not recognize dual citizenship until much later, until the 1960s, I think it was, under a different Supreme Court decision. This was repealed in 1922 as a result of the 19th Amendment, which established the right to voting for women in 1920. So we're seeing a pattern here where sometimes the Supreme Court will enact something or Congress will enact something and then another legislative body will reinforce it. The idea is that we built on precedent to create a judicial system that over the course of the 20th century will hopefully become more inclusive as time progresses. Still, there are exceptions to this question of citizenship. There are people who did not qualify for naturalization. Under the Chinese Exclusion Act, which remained in place until 1943, people from China, both of Chinese descent and more recent Chinese arrivals, were excluded from the United States. It was enforced more strictly in the late 19th century than in the early 20th century, but nonetheless, the law remained in place. And even more explicitly, in 1924, Congress passes what is known as the Immigration Act. This law specifically favors Europeans. The idea with enticing European immigrants, particularly to northern United States industrial centers such as New York and parts of the Midwest such as Chicago, was to introduce a white labor force that would replace or compete with the labor force that was moving from the U.S. South as part of the Great Migration, as African Americans were largely leaving the South, moving northward for reasons that are tied to segregation. So the Immigration Act of 1924 is directly speaking to the question of who is a desirable American or who qualifies as American. And this is further reinforced during World War II with FDR's executive order, which bans or rather establishes Japanese internment camps for any person of Japanese descent within 100 miles of the western coastline. Now that seems pretty specific, and it was. It also happened to have been the case demographically that was where most people of Japanese descent lived in the United States during that period. So it was a kind of quota law, if you will. What about everybody else, though? What about this question of equal citizenship under the 14th Amendment, the Due Protection Clause? Are all citizens equal? This was something else that the United States had to wrestle with as it moved into the era of the 20th century. So some of you may know that in 1898, there was a conflict known as the Spanish-American War. This is actually a misnomer. It's known as the War of 1898 or the War for Cuban Independence. In Cuba, it largely began with Cuba seeking its independence from Spain in what was then its third attempt to do so. The United States intervened and in the process acquired Puerto Rico, Guam, and the Philippines. It also indirectly acquired control of Cuba for much of the early 20th century. Puerto Rico, Guam, and the Philippines, and later other islands were part of what were known as unincorporated territories. Did the Constitution follow the flag? If the United States acquired these islands as a result of its intervention in the War of 1898, what would happen to the citizenship rights of those people? Would they be considered U.S. Americans? In a series of 3 or 4 Supreme Court cases in 1901, known as the Insular cases, the Supreme Court ruled not necessarily. They were called insular cases because they pertained to these islands. Insular is a fancy term for island. And the Supreme Court established what it referred to as the doctrine of territorial incorporation, which established a distinction between incorporated and unincorporated territories. In effect, this meant annexation without rights. Only certain islands would be considered incorporated territories, that is to say, Alaska and Hawaii, which later went on to become US states. The other islands were to remain and still remain unincorporated territories, with the exception of the Philippines, which later acquired independence. If we look at Puerto Rico as a case study, we can see how this played out in practice. Puerto Ricans were drawn into the expanding realm of the US empire during this period following the War of 1898, yet they did not enjoy the right to US citizenship until 1917, when Congress decreed that after much controversy and lobbying. You might be wondering why. Well, much of this had to do with demographics. Most of Puerto Rico and certainly most of Cuba were populations of predominantly African descent. The United States did not want to incorporate them largely for those reasons. But in practice, Puerto Rico became annexed to the United States. It became tied to a system of commercial exchanges. It became tied to the United States military machinations during this period. And of course, more recently, it's become a major tourist hub. So Puerto Ricans on the island have US citizenship. They gained US citizenship in 1917, but they do not have direct congressional representation, nor can they vote in federal elections unless they have an address on the mainland. Such was not the case, however, with Alaska and Hawaii, which became fully incorporated into the United States as US states. More complicated reasons in the case for why Puerto Rico later did not become a US state, but the principle remained in place that there would be this distinction between incorporated and unincorporated territories, a distinction more fundamentally rooted, once again, in the legacies of the 14th Amendment. So continuing the story here, let's fast forward a bit to World War II. We already see the origins of modern day globalization with the War of 1898, and World War II further increased that trend. We have on the right here an image from Google of a naturalization ceremony. And the question becomes then, what will happen as the world becomes more globalized during this period, what will happen to immigrants? Will they be granted citizenship or will they be excluded? During World War II, the United States largely closes its borders. Some of you may know accounts of ships bearing Jewish people from Eastern Europe that were denied entry into the United States. And we also have the continuation of quota laws during this period. In fact, quota laws were not really abolished until much later, until 1965. Undergirding then this trend of globalization and, we might say, either exclusion or selective acceptance is the Immigration Act, once again, of 1924, which explicitly favored Europeans as quote-unquote desirable immigrants, with the exception of those who had leftist political views. A series of Red Scares in the 1920s, known as the Palmer Raids, and then later on during the McCarthy era of the 1950s, deterred and, in fact, prosecuted leftists from entering the United States. There were cases, too, when the United States prosecuted some of its own citizens on account of their leftist beliefs, irrespective of the fact that those rights to dissident political beliefs were protected under the US Constitution, under the principle of free speech in the First Amendment. We also have another precursor to this new chapter in exclusion that emerges after World War II, a Supreme Court case in 1922. Ozawa versus the United States, in which the Supreme Court ruled that Asians were to be excluded from naturalization. So those of European descent could become naturalized. We see this quite clearly with Italian and Irish Americans, but those of Asian descent are excluded from naturalization, according to what the Supreme Court determined in this 1922 case. Only about 20 years later, with the U.S. entry into World War II, do we see this case further reinforced with the establishment of those Japanese internment camps that I previously referenced. Now, I've emphasized these two groups, Chinese and Japanese Americans, as groups that were considered, quote unquote, perpetual foreigners, as some legislators argued throughout the 20th century. But they weren't the only group that was excluded from the United States body politic. We also had Mexicans, immediately south of the United States. The U.S.-Mexico border had, since the early 20th century, been a site of contestation over inclusion and exclusion into the United States. During the Great Depression, Mexicans and Mexican Americans, mostly in the Southwest, working in agriculture, were, quote unquote, repatriated or deported. This was justified through economic arguments. During the Great Depression, the economy was in a state of stagnation. So the argument went, let's remove non-Americans or perceived non-Americans so that Americans can succeed economically. Now, this was an argument that was not entirely accurate in practice, but which nonetheless became recycled another 20 or 30 years later under what was known as, this was the term of this legislation, Operation Wetback, in which Mexicans and Mexican Americans were once again deported, primarily again in California and the Southwest, using the same kind of economic arguments that had been developed a generation earlier. Now, what may be particularly alarming about these cases is that there were some U.S. citizens who were deported, that is to say, Mexican Americans who were U.S. citizens, and they were lumped into this group that was targeted for deportation because immigration authorities did not care to draw that distinction, raising the question, was this really about economics, or was this about the racial composition of the United States during this period? To dive a little bit more deeply into the quota laws enshrined in the 1924 Immigration Act, we should note that people from the Middle East and Southeast Asia were specifically targeted. The numbers vary depending on the years, and there are some other quota laws that are passed within this 40-year period, but essentially on average, there was a cap of about 30,000 immigrants per year coming from the Middle East or Southeast Asia. Many of the immigrants coming from the Middle East were fleeing military conflicts there, and they resettled in various parts of the country. Now, in 1965, Congress passed what was known as the Immigration and Nationality Act, and there was sort of a part B to the story about 20 years later. But essentially, this act abolished these quota laws, and I won't have time to get into this. I'm looking at the clock now, but by removing these quota laws, I want to emphasize that it did not necessarily change the rules of the game. It just kind of changed how the game was played, if you will, which is to say that there were still other mechanisms through which people were placed in different tiers of citizenship, again, in violation of the Equal Protection Clause of the 14th Amendment. So in the interest of time, I want to fast forward now to this last slide and touch on some of the current issues currently related to immigration law. If you're interested in the concept of denaturalization, which has become a hot button issue in the last 2 weeks or so, I recommend this book by Patrick Real. He is a constitutional law professor or scholar. titled The Sovereign Citizen, Denaturalization, and the Origins of the American Republic. Wheel's argument is that denaturalization is in fact quite central to the making of citizenship law. Beyond exclusion, there are examples, historical examples, in which people were deprived of their citizenship. So I want to emphasize here the distinctions that exist in theory. It's yet to see how these will play out in practice, but theoretically, denaturalization is a type of civil case. It is not a criminal case. Now, this is important because it means that if someone who has been targeted for denaturalization, and I'll talk about who may qualify, quote unquote, qualify for that in a minute, someone who's been targeted for denaturalization, because it's a civil case, they may have legal representation, but they are not automatically entitled to it, as people would be under criminal cases, as part of the habeas corpus system that is enshrined in the Constitution. Now, what may target someone for denaturalization? Theoretically, there are a couple criteria. First of all, it only applies to those who are naturalized. That is, not to those who were born as U.S. citizens, because the 14th Amendment establishes very explicitly that those born in the United States are U.S. citizens. If we are following the Constitution, the only thing that could possibly change that would be a constitutional amendment, which would require a congressional supermajority, and it would require the states to approve it as well. So I want to let us sit with that for a minute. But under this type of trial, denaturalization trial, those citizens who gained their citizenship not by birth, but rather through the process of obtaining citizenship or naturalization, may lose their citizenship if and only if, theoretically, the citizenship was obtained illegally, or it was obtained through either a falsification or misrepresentation of the facts. Bit abstract, but essentially, if someone seeks U.S. citizenship on, say, asylum grounds, and citizenship court grants that request on those grounds, and later it's revealed that the asylum case was in fact a fabrication. Perhaps they sought citizenship for economic reasons. They left their home country for economic reasons. That is not a consideration typically for naturalization, certainly not under asylum provisions. That may constitute grounds for denaturalization, as an example. Other types of crimes are typically excluded from this. So it really theoretically only pertains to whether the citizenship was obtained through illicit means. So someone may have been a criminal in another instance, but if they obtain their citizenship legally, can they be naturalized? Well, denaturalized? Well, the gray area comes into play where if you're asked as part of your naturalization hearing whether you committed a crime and you said no, and later it was revealed that you had, this is a bit of a gray area. Historically, it's almost always been the case that such people could not be denaturalized, but actually under the Obama administration, Obama began opening up a series of investigations into people who potentially lied about committing crimes as part of the citizenship process, but had not necessarily committed a crime within the provisions that they were using to apply for citizenship. So the distinction is really highly technical, yet it's far-reaching in its consequences. Now, with calls for denaturalization being weaponized quite broadly, the question remains whether birthright citizens can be denaturalized. This is sort of a logical extension of that question. And in theory, no, because the 14th Amendment explicitly prohibits that, but we've already seen some of the ways in which the principles of jus soli, or birthright citizenship, and habeas corpus, or due process, have been subverted in very recent times. And this, of course, is concerning to a number of observers. So let's look at another example that is aside from this question of denaturalization that is very much a hot button issue now. It's called TPS, which is closely tied to the DREAM Act. TPS, or Temporary Protected Status, was established by Congress in 1990 as an asylum protection. It did not necessarily place people on a pathway to citizenship, but it allowed them to come to the United States with authorization, live here, work here, potentially seek citizenship, but more importantly, prevent them from being deported. Certainly if they were paying their taxes and not committing crimes. This was partially revoked last week. There are about half a dozen countries that were included in the most recent version of this agreement, and the countries that were excluded from this last week were Honduras and I think either Nicaragua or Venezuela. I'd have to double check. But countries in Latin America, we have seen a shift in the last 50, 70 years or so from laws that targeted people of Asian descent toward laws that targeted people of Latin American descent in the United States. I don't have time to really cover this, but I want to emphasize this shift and note that with the revocation, partial revocation of TPS, this is yet another way in which immigration provisions have been hollowed out or restricted in more recent years after a period of general expansion throughout much of the 20th century. And finally, closely related to TPS, we have what is known as the DREAM Act, a piece of legislation that's been introduced several times in various ways, but has never passed in Congress, which would establish a pathway to citizenship or at least permanent residency for the children who are born or were not born in the United States, but rather came with their parents to the United States. And there are certain conditions to this in various forms of the bill. One form under President Obama is known as the Deferred Childhood Arrivals Act, which he passed in 2012, essentially protecting certain children from deportation. This is tied to TPS insofar as both are sort of stopgap solutions. They're kind of asylum protections. In most cases, many people who hold DACA, those recipients may be coming from countries that are experiencing a certain degree of political instability, and they are economically contributing to the United States, paying taxes and so forth. These are the arguments that have been used in favor of these kinds of provisions. In 2022, the courts ruled that new cases of DACA would not be heard, and the current status of DACA recipients is somewhat uncertain. So in closing, I want to note that all of these issues that we've covered today, we've covered a lot of ground, and we're really just scraping the tip of the iceberg here. There's so much more we could cover, but at the end of the day, it all goes back to the 14th Amendment. And this phrase, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. So I'll end on that note and save a couple minutes for questions, and I know other folks want to present. So thank you very much for having me. It's been a pleasure.
Thank you so much, Dr. Hernandez. I've got my eye on the Q&A in case anyone wants to put anything through. In the meantime, I will introduce our next speaker, Andrew Yeh. And Andrew is one of our students who is working on an immigration project that he will tell you more about. And if you have questions for either of them and we miss them, I will put my email in the chat and you can always email me. I will pass those questions on.
Great. My name's Andrew. I'm a rising senior in high school, and I just want to talk to you about my experience with immigration law as a student and maybe how other students in youth advocates can get involved. So a few ways that I'm involved in immigration law. Firstly is my internship. The way that I got that is I asked probably 20 to 25 different law firms to see if they would let me come in one day, shadow them, and just, see what they do on a daily basis. I think I had like 10 rejections, like 9 of them didn't respond, but then one of them said yes. And now I've been working with them for around a year and a half. When I first started out, I was really new to the process. I'd gotten into immigration law because of my parents. They came on student visas, got work visas, and then eventually got their green card. But yeah, when I first started, I did a ton of research about, the whole immigration from the legal side, like how to navigate the legal system. And obviously that's changing daily by the looks of it now. But I decided to document all of my research, and I'm going to publish a book of some sort that sort of goes over how to have legal status in the US and how you can stay in the US permanently. But through my internship recently, I've also worked on a lot of like actual cases. So it's been really cool to sort of see, the humanity side and like the stories of different people that you read about on the news, but they're also very local as well. A second way that I'm involved is through writing and speaking. So I'm planning to host a speaker event at my school where we talk about current events, and I'm going to do mine about immigration and just understanding that, it's a really confusing time because a lot of the language that they use is really vague, and a lot of times you don't know what's being challenged. So like an example of that is President Trump tried to get rid of birthright citizenship. Obviously that's unconstitutional, but a common misconception is that the Supreme Court case they had ruled it as constitutional. Whereas in that case, they actually just ruled that, district judges can't block executive orders for the entire country. There was no ruling on birthright citizenship, even though, it is constitutional, and any attempt to get rid of it would definitely be challenged and overturned by the Supreme Court. And the last way that, students can get involved is advocacy. I live in North Carolina, so I try to write to both of my senators, asking them to pass legislation that, gives refuge to immigrants, but you probably ignored that. But, in my state, there's a lot of protests. Like I know there was a countrywide protest, like the No Kings protest, and there's a lot of events in my state where people can get informed about immigration law and their rights. And just me being able to go to those events is so eye-opening to see, in my community, there are so many people whose lives are literally on the line, and like signing pieces of legislation could literally like turn their whole life upside down. So yeah, just some examples of some student initiatives that I have. So obviously there's the internship, and I've also started a club at my school. This club focuses on developing writing skills and public speaking skills, but we sort of focus on a lot of current events that happen right now, and we just so happen to be doing a lot of immigration work. So yeah, I would say, right now, I think immigration law needs a lot of youth voices and youth advocates. So it's important to, get out there, use your voice, and advocate for those who really can't. And one last thing is that students should always be super up to date about what's happening because, as I said previously, it's changing daily. So being able to really understand what has changed and being able to communicate that with your community is extremely important because, maybe not everyone is getting the most accurate news. So yeah, student involvement, I have an internship, speaking writing program, and advocacy. And yeah, I hope to see you get involved in immigration law.
Amazing. Thank you so much, Andrew and Dr. Hernandez. So I also have a legal background, and I will say, to sort of close things up, that it's hard to balance the semantics versus the actual families that are being torn apart or, stuck in some place where they aren't safe. And, as scholars, which I'm sure probably most of the people in this chat or in the audience are, we have a double goal. right? We want to set the record straight, but we also want to make real world change. So the more we keep that in mind, hopefully, the stronger and more long lasting the progress we make will be. So thank you both for being part of that. Thank you for everyone who attended. I saw some of my students in there, some of Maya's students. The recording will be available online. You can always get to it through our website or through our YouTube channel. And right now, I'm about to put my email address in the chat for anyone who has questions later and would like me to pass them on to one of our panelists. And with that, I will say thank you all so much for coming and have a great Sunday.